written a civil infraction or a ticket for defective tires. What were your tires like?
Defective. I mean, they were just bald, not like slick bald, but below your dye mark that you're supposed to have on them.
All right, Mr. Parks, there's certain ways in which the court can accept a plea based on factual basis. And from what I'm hearing right now, I don't have enough to accept a plea to all of the charges. And that's nothing that you've done or nothing that you've said or not said. It's just based on what you've told me so far. I can't accept the plea, especially to count number 3. So what is going to happen next is I'm going to have to set the matter for a pretrial. Information accurate?
The stuff that I gave the person just now. Yeah, yes.
Your address and phone number, all that was accurate?
Yep, 1490 Helena. I can give you the phone number again if you want to. 947.
I've got it. Ends in 7608.
Yep.
All right. And did you have the opportunity to meet with somebody from the defender's office today?
Yeah.
I have a complaint that alleges that on or about April 18th, 2026, in the township of Antioch in Wexford County, it is alleged in count number 1 that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, and reimbursements for cost of governmental expenses and prosecution. In count number 2, it's alleged that you committed the offense of operating a motor vehicle without security or insurance. That is a misdemeanor punishable by up to 1 year in jail and or a fine of not less than $200 nor more than $500. In count number 3, it's alleged that you committed the offense of reckless driving. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Sure.
Did you read and sign an advice of rights form at the jail? Talk about your rights to an attorney and your rights to a trial?
Were they given to me?
Well, that's what I'm asking. Did you
Yes,
sign
yes.
that? Did you read and
Yeah.
sign that form?
I think that's what I have here. Yeah.
It was given to you earlier, you read it, you signed it, and you handed it back to the office.
Yeah, I did.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Just gonna represent myself.
So before we can do that, I have to make sure that that's a accurate waiver. So give me just a second. There's a form I need to fill out. So how many years of education do you have?
I finished high school.
All right. All right, so this form says I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime, and I have read or have had read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I had the right to be represented by a lawyer at all stages of this process, and that the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision, and I have 12 years of education. I read and understand the English language, and I am mentally sound. Mr. Parks, having gone through that, do you still wish to continue to represent yourself?
Yes, sir.
All right. If at any point you decide that you want the court to make a referral to the public defender's office, all you need to do is let us know that, and we'll make that referral. And that's something we'll go over each time that we have you in court. So today you have a couple options available to you. One is to plead guilty. If you pled guilty, all 3 misdemeanors would enter on your record, and we would not be able to sentence today because it is required that you have a substance use assessment completed. If you pled not guilty, we would set the matter for a pretrial, which would then give you the opportunity to discuss the case with the prosecutor and see if there's a way to resolve it other than guilty pleas or going to trial. Do you understand those 2 options?
Yep,
Then how do you plead today? Guilty or not guilty?
I am guilty.
All right. Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
By God.
All right, you may put your hand down. Has anybody promised you anything in order to get you to plead today?
Nope.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes, it is.
Back on April 18th, were you on probation or parole?
No.
Were you on bond in any other file?
And any other what?
In any other file?
I don't think so.
Were you under the supervision of any court?
No.
All right. I know we just went through your rights with you. Do you have any questions about those rights? Or I'm sorry, we discussed those rights. Do you have any questions for me about them?
No, I don't think so.
Well, now's your chance. So do you or don't you?
Nope.
Most importantly, do you understand that you have the right to have a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yeah.
Your Honor, I don't know if this would be appropriate, but just to make sure he protects his rights, he is looking tired and maybe intoxicated still. Has he been tested?
Do we know what his level was at the time of his arrest, Ms. Doe?
0.14, 0.15.
This happened 2 days ago, so I think he's sober.
All right.
But thank you for that, Mr. Hartel. Ms. Doe, are you aware of any promises, threats, or inducements not made part of the record?
I'm not.
Then Mr. Parks, to the allegation then that on or about April 18th, 2026 in Antioch Township of Wexford County, how do you plead to count number 1 of operating while intoxicated?
Guilty.
And to count number 2 of operating a motor vehicle without security? How do you plead?
Guilty.
And to count number 3 of reckless driving, how do you plead?
Well, I guess due to the first one, that's guilty.
In order to accept those guilty pleas, I must have you tell me what it is that makes you guilty. So back on April 18th, were you operating a motor vehicle in Antioch Township of Wexford County?
Yep. Yes.
And prior to operating that motor vehicle, had you consumed alcohol?
It was in my system.
Or was it in your system because you consumed it?
That's the only way it gets there, so, yeah.
How much had you had to drink?
There's just a couple beers. Those just a couple beers.
Ms. Dahl, what did you say the intox leisure was?
157.145.
So, Mr. Parks, the prosecutor says that when they did your breath test back at the jail, you blew a .157 and a .145. Do you stipulate or agree to using those results for purposes of the plea?
I mean, yeah.
All right. Do you have any reason to doubt those results?
Nope.
Was that a no? I couldn't hear you. I need you to answer me. I
Nope.
can't accept a.
No.
Then to count number 2, that you operated a 2012 Ford F-150 without insurance. Were you the owner of that vehicle?
Yes.
And did you know that it didn't have insurance?
Yes, I believe it was that Friday that my insurance, they had just sent me a letter saying that it wasn't gonna work anymore. What was it? Something got deferred, and so I wasn't getting paid until the upcoming week, so.
So
No,
that
I
the
did
letter
not.
you received,
I had no insurance. It was from Bristol West.
was from what? I'm sorry?
Bristol West, the insurance company.
All right, but you knew that they had canceled your insurance.
Yep.
And then to count number 3 of reckless driving, what did you do that made you a reckless driver?
Probably operating while intoxicated would make me a reckless driver.
Do you know what you did?
Crash my truck.
How? So do you have any memory of how you were driving before you wrecked your truck?
So on a straightaway, rear wheels kicked out. It was raining. When I came off the road, and by then I was closing my eyes because I realized I was gonna go off the road. So
You realized what?
I was going off the road.
Now, did you say your wheels kicked out?
Rear wheels lost traction.
Do you know how fast you were going at the time?
I was probably going at least 5 over. It was like 65.
How? Did law enforcement see you driving?
No. From what I have been told, there was a call, and then they called people afterwards.
You were written a civil infraction or a ticket for defective tires. What were your tires like?
Defective? I mean, they were just bald, not like slick bald, but below your dye mark that you're supposed to have on them.
Right, Mr. Parks, there's certain ways in which the court can accept a plea based on factual basis. And from what I'm hearing right now, I don't have enough to accept a plea to all of the charges. And that's nothing that you've done or nothing that you've said or not said. It's just based on what you've told me so far. I can't accept the plea, especially to count number 3. So what is going to happen next is I'm going to have to set the matter for a pretrial. So I'm going to enter not guilty pleas. I'm going to set the matter for a pretrial, and that will give you the opportunity to discuss the issues with the prosecutor and see if there's just see if the case gets presented to me differently, or if there's a plea agreement that can be worked out. But based on what you've told me, I can't find you guilty of all the charges. So knowing that, do you still wish to continue to represent yourself, or do you want the court to make a referral for an appointment of an attorney?
Is there any negative possibility, any negative things to me doing that? Or just the possibility of a conversation at that point, right?
Well, if they take the appointment, if you meet the requirements for indigent defense, they would represent you in court. You might get charged an attorney fee. Usually, if I do order those, it's $150 or less. And a lot of the times the public defenders will waive them. So I don't know what will happen in this case, because I can't make that prejudgment, but that's a potential outcome that you could have. Obviously, an attorney would be able to walk you through the process. They would be able to review the evidence, see whether or not whether or not you have any type of defense to any of the charges you have, and perhaps even be able to negotiate a different plea agreement.
Well, I guess why not? Let's do that shit. Yeah.
All right. So we will make a referral to the public defender's office for the appointment of an attorney. I'm going to enter a not guilty plea, and we'll set the matter for that pretrial that we talked about. Now that gets us to bond, and bond is based upon the risk that you pose to society and the likelihood of you appearing at future court appointments. Where is Heartland at? I'm not familiar with that town.
I believe it's Livingston County, right outside of Oakland County. It's like right here. It's about 3.5 hours southwest. I have family up here, and I was coming to visit Tibby Dam for the weekend, so I had no live up here. And then,
all right. So I don't want you to say anything else about the case, because you've got the right to remain silent. So, is there anything that would stop you from coming back to court?
No, I actually have court up here soon.
All right. Counsel, I do not show any prior history for Mr. Parks, and the praxis scores him at a risk level 2. But I don't know how I do know how he's scoring that way. So one is his length of residence. He hasn't been at that residence for a year. But Mr. Parks, you self-reported, it looks like, or somehow community corrections have you down for having a prior conviction. Have you been criminally convicted somewhere before?
Criminally convicted?
Yeah, so I see some driving offenses, but actually an actual conviction for a crime, I don't see any. So have you been?
I got a public intoxication in Texas once.
Okay.
If that's what the criminal thing is, that's the only thing I can think of. Other than that, that's all.
All right, so that's not showing in our records. Not knowing whether that's been expunged or whether or not there was truly a conviction. Is there any objection to rescoring down to a 1 on this, Ms. Dull? Mr. Hartel?
Oh, I would never object to going down.
All right, so we will change history or the praxis to a risk level 1. Any comment regarding bond, Mr. Hartel?
Yes, thank you, Your Honor. Not only is that a low practice score with possibly a misdemeanor, but his family is here for moral support. I believe father or grandfather, if I recall correctly. I did speak with them briefly before court. I know they were going to encourage him to use a public defender if he didn't use one today, although he might have been less for us to do if the plea had gone through, I'll put it that way. But what I would ask the court to do is grant a personal recognizance bond. I believe that's appropriate. He does have strong ties, at least to the state of Michigan, at least some ties to our local community. And even if he does spend the time down there in Heartland, I'm sure they could set up random testing, things of that nature. I don't doubt the court is going to require some level of testing. I didn't get this much detail with him when I was meeting with him earlier, but I would encourage him to consider the daily testing machine. I believe that might be easier for him. But again, I don't know if the court's going to require random or daily, but I do believe either way, a PR bond is appropriate, especially with the amount of support his father and grandfather have noted that they will be placing. I don't want to put too much burden on them and say they're going to be babysitting, but they're definitely going to be following up with them. I'll phrase it that way. Thank you.
Thank you, Ms. Dahl.
Your Honor, the people's concern in this situation is the safety of the community. Due to the level of intoxication, also in the police report states that he tried to pass on the shoulder and then eventually ended up losing control and crashing his truck that was upside down into the trees. So a very serious accident. So I would ask the court to do either daily testing or random alcohol testing also because he self-reported that he has a public intoxication conviction in other states. So it seems like alcohol has been an issue for him. Thank you.
All right, Mr. Parks, I am going to release you on your personal recognizance, which is your promise to come back to court with some conditions. That you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not consume any alcohol, and you'll be subject to random testing. If you want to take the daily machine home with you, that's an option you have, but I'm not ordering that. It is $10 a day to have that machine, though, just so you're aware. I'm also going to order no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that as well. I believe those bond conditions are appropriate to help protect society, given the level of intoxication in this case that was discovered during the plea taking process, 0.157 and a 0.145. Also based on the self-reported public intoxication out of Texas. Even though I didn't score it, it still does cause the court some concern. And I believe the no controlled substance, including recreational marijuana, is appropriate because I don't want one substance traded for another. So, Mr. Parks, at some point, you're going to be released from the jail today. You'll need to come over here to the courthouse, which is about 5 blocks from where you're at. Go to the community corrections office and get signed up for your testing requirements, and then they can discuss with you what options you have and how testing works. Before you leave the courthouse today, you'll have your next court date. So make sure you keep that court date. And then you should be hearing from the public defender's office within a couple of days. Do you have any questions for me about your bond conditions?
No, why would I want to have that daily testing machine? Is there positives to that?
Well, one of the positives is that you wouldn't have to call in every day and try to find a testing facility to test you. You'd be given certain times that you would have to blow on the machine, and then that would be your alcohol test. So that's one advantage, but I'm not ordering it, but that's an option you have as opposed to doing the random alcohol testings. You'll still have to do the random drug tests. Those will still be random.
Okay.
All right.
Understood. Yep.
All right. Thank you. Thank you, jail. I think we've got one more there.
Yes, Your Honor, just one moment.
Mr. Fick. Good afternoon. Sir, what is a good mailing address for you? Sir, you're here on a bench warrant for fail to appear for a financial review hearing. Set for financial review hearing back on October 30th. I see a bond was posted, which we currently owed the court $362.60. I see a $363 bond was posted, but that wasn't posted. Was that posted by you?
No, my stepbrother posted it.
All right. So,
I did have a payment just plan set up.
uh-huh.
For some reason, when I called up here, they put it on a different fine. Just to pay it.
All right.
I'm like, you know what fine I'm putting on? I haven't changed it, so. It's the same one.
Do you have, so it looks like there's two cases we have here. Do you have cases in the other
Well,
court?
I don't make sense.
Okay.
They tried saying they don't have record from me bonding out last time when I called up here. That's another issue that I'm dealing with. So they said that I haven't been here. I'll go for it.
All right. Well, do you want to get set back up on one of those
Yes, sir.
payment plan again?
Yeah.
How much can you do a month?
Let's keep the same plan I had. Just do the
25? When can you make that first payment?
I'll be back. I can do it today.
And then do you want to do like the first of the month, last of the month? What works better for you?
Or whatever, first, yeah.
All right.
I'm pretty sure you remember last time, though.
I know we were back here in, looks like April. Yep. And then we set it for financial review hearing in the 3 months, and that's the one you missed. So we're gonna go ahead and we'll reset it again for another financial review hearing. So you'll get that when, you'll get your next court date at the window. So I'll need you to go out there and get that, and then you can make that payment. And like I said last time, as long as you're showing good faith, I'll work with you on that. Okay?
Yep.
Thank you. A person at the jail, please state your name for the record.
James Simons.
All right, Mr. Simons, I'm Judge Wiggins with the 84th District Court. You're here on a bench warrant for fail to appear at a financial review hearing back in March. I see Community Corrections spoke with you this morning, and you don't have a mailing address or phone number, is that correct?
Not at the time.
All right. I show that you currently owe the court $310. I assume you can't make a payment on that today?
No,
Are you able to commit to any type of monthly payment at all?
I don't even have an income. I don't even have an income coming in at this time.
All right. So what I'm going to do is I'm going to release you from the jail on your on a PR. And we're going to reset this for another review hearing in 3 months. So you'll have that next court date before you leave the jail today. If you're able to start making a payment, that's great. Go ahead and do that. But if not, we'll see you back here in 3 months, and we'll discuss your finances at that time again. All right.
All right.
All right. Thank you. Thank you, jail.
Thank you, Your Honor.
And that's it for today.
This courtroom moment started like a normal legal argument, but slowly turned into a complete breakdown of one side's case. Two lawyers were debating a technical issue: when exactly a claim was denied and whether certain documents counted as a proper denial. One side kept insisting that every explanation of benefits, every document they sent, should be treated as a denial. On paper, it sounded logical, but in court, logic alone isn't enough. The judge listened carefully, letting them speak, but you could tell he wasn't convinced. Then he stepped in and changed the entire direction of the case with one line. "I'm not buying that." That moment hit hard, because suddenly all those arguments lost their weight. The judge made it clear that a denial isn't something you assume. It has to be clear, formal, and undeniable. He kept pushing, asking a simple but powerful question. If that's not the denial, then what is? And that's where the problem began. The lawyer who was confident moments ago didn't have a strong answer. The pressure flipped instantly. The judge then chose to go with the other side's timeline, locking in a date that changed everything: deadlines, claims, and the entire outcome of the case. And just like that, after all the back and forth, the judge ended it in the simplest way possible. Motion denied. No drama, no long explanation, just a final decision. And it leaves one important thought. In court, it's not about how convincing you sound. It's about what you can actually prove.